Hello students, I am Dr. Harpreet Kaur from Army Institute of Law. I will be discussing the topic of due process of law and fair trial. Introducing the topic, the right to a fair trial is one of the most litigated human rights and forms a core part of the international human right framework. Ban Ki-moon. The due process of law is a fundamental principle of justice that guarantees that every person is entitled to a fair and impartial hearing before a competent and independent authority in accordance with established rules and procedures. The right to fair trial is a corollary to a due process of law which ensures that the accused persons are presumed innocent until proven guilty and that they have the opportunity to defend themselves against the charges and evidence presented by the prosecution. In India, the due process of law and the right to fair trial are enshrined in the Constitution as well as in various statutes, case laws and international conventions. However, there are also many challenges and issues that affect the implementation and realization of these rights in practice. The historical, constitutional, judicial and practical aspect of the due process of law and the right to fair trial in India will be elaborated upon hereafter. Coming to the historical evolution. The historical evolution of the due process of law in India can be traced back to the ancient and medieval times when the concept of dharma or natural justice was prevalent in society. The dharma was the moral and legal code that governed the conduct of individuals and the state, and it was derived from the Vedas, the Smritis, the Puranas and other sources of Hindu law. The dharma also recognized the rights and duties of the people and provided for the administration of justice through various courts and tribunals. However, the modern concept of due process of law in India is largely influenced by the British colonial rule and the American constitutional jurisprudence. The British introduced the common law system in India, which was based on the Magna Carta doctrine of 1215. The Magna Carta was a charter of rights and liberties that was issued by King John of England to the barons and the clergy, and it established the principle that no one is above the law and every person has a right to fair trial by a jury of his peers. The Magna Carta also influenced the American Declaration of Independence and the Bill of Rights, which incorporated the due process of law as a fundamental right of the citizens. The due process of law in India was further developed by the Indian independence movement and the Constituent Assembly, which drafted the Constitution of India in 1950. The Constitution of India adopted the concept of procedure established by law under Article 21, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. However, unlike the American Constitution, which explicitly mentions the due process of law under the 5th and the 14th Amendments, the Indian Constitution does not use the term due process of law anywhere. This was because some members of the Constituent Assembly were of the view that the due process of law was too vague and subjective and it would give too much power to the judiciary to review the legislative and executive actions. Therefore, they preferred the procedure established by law, which was more objective and specific and which meant that law enacted by the Parliament or the state legislature was the final authority and the courts could not question its validity or fairness. Coming to the constitutional perspective and the statutory provisions. The due process of law in India is derived from Article 21 of the Constitution, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. However, the Supreme Court has interpreted this article in a broad and a liberal manner and has expanded the scope and content of right to life and personal liberty. The Supreme Court has held that the procedure established by law under Article 21 must not only be fair, just and reasonable, but also in conformity with the principles of natural justice and other fundamental rights guaranteed by the Constitution. Therefore, the procedure established by law under Article 21 has acquired the essence and spirit of the due process of law under the American Constitution. The Supreme Court has also held that due process of law in India is not only applicable to the executive actions but also to the legislative actions. The Supreme Court has declared that the Parliament or the state legislature cannot make any law that obliges or take away the fundamental rights of the citizen, and that the courts have the power to strike down such law as unconstitutional and void. The Supreme Court has also laid down various tests and criteria to determine the validity and reasonableness of the law, such as the doctrine of proportionality, the doctrine of arbitrariness, the doctrine of legitimate expectation and the doctrine of non-retroactivity. Thus, the due process of law in India is a safeguard against both the executive and legislative tyranny and a guarantee of the rule of law and the constitutional democracy. The right to fair trial includes various rights and principles such as presumption of innocence, the independent, impartial and competent judge, the expeditious trial, the hearing in open court, the knowledge of acquisition and adequate opportunity, the trial in presence of accused, the evidence to be taken in presence of accused, the cross examination of prosecution witness, the prohibition of double jeopardy, the legal aid, the right to appeal, the right to defense, the right to be tried and the right to be presumed innocent until proven otherwise. These rights and principles are derived from the Constitution of India, the Code of Criminal Procedure 1973, the Indian Evidence Act 1872, the Indian Penal Code 1860 and other statutes, as well as from various case laws, international treaties and conventions such as Universal Declaration of Human Rights 1948, the International Covenant on Civil and Political Rights 1966 and international conventions on the elimination of all form of racial discrimination 1965. The key constitutional and statutory provisions besides Article 21 are as follow. First is Article 14 of the Constitution. The state shall not deny to any person equality before law or equal protection of laws within the territory of India. This article ensures that every person is treated equally and fairly by the law, and that there is no discrimination or arbitrariness in the administration of justice. Article 19 of the Constitution states, all the citizens shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form association or union, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade or business. This article protects the right to free expression and association, which are essential for the exercise of the right to due process of law and fair trial. Article 20 of the Constitution states that no person shall be convicted of any offence except for the violation of law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. No person shall be prosecuted and punished for the same offence more than once. No person accused of any offence shall be compelled to be a witness against himself. This article protects the right against ex post facto law, double jeopardy and self-incrimination, which are fundamental principles of due process of law and fair trial. Article 22 of the Constitution states, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. This article protects the right to be informed of the grounds of arrest, the right to legal representation and the right to be produced before a magistrate within 24 hours, which are essential for the right to due process of law and fair trial. Article 32 of the Constitution provides the right to constitutional remedies. Coming to the Code of Criminal Procedure, Section 243 Clause 2 of CRPC 1973 states that the accused shall be entitled to adduce any evidence to show that he has not committed the offence allegedly against him, or that there are grounds for believing that he may not be guilty of such offence. Section 167 of CRPC 1973 deals with the procedure when the investigation cannot be completed in 24 hours and the police officer has to produce the accused before a magistrate who can authorize the detention of the accused for a period not exceeding 15 days in the whole. Section 173 of CRPC deals with the report of the police officer on completion of investigation and the submission of charge sheet or the final report to the magistrate who can take cognizance of the offence and issue process to the accused. Section 197 of CRPC deals with the prosecution of judge and public servants and provide that no court shall take cognizance of any offence alleged to have been committed by them while acting or purporting to act in the discharge of their official duty, except with the previous sanction of the competent authority. Section 200 of CRPC 1973, this section deals with the examination of the complainant and provides that the magistrate taking cognizance of an offence on a complaint shall examine the complainant and the witnesses present, if any, on oath and reduce the substance of their examination to writing. Section 277 of CRPC 1973 deals with discharge and Section 228 deals with the framing of the charge or order for trial. Section 239 provides when accused shall be discharged and Section 240 provides framing of the charges. Further, Section 265A to 265L deals with the plea bargaining. Another key provisions which ensure fair trial is Section 313, which postulates the power to examine the accused. Further, Section 327 provides the court to be open. Last but not the least, the Honorable High Courts are vested with the inherent power under Section 482 to do complete justice, which includes to ensure fair trial and the due process of law is followed. Thus, the main procedural law, that is the CRPC 1973, governs the conduct of the criminal trial in India efficiently. It contains various provisions that ensures the due process of law and fair trial, such as right to bail, right to speedy trial, right to cross-examine, the prosecution witnesses, the right to adduce evidence in defense, the right to appeal, the right to free legal aid, the right to fair and impartial trial by the competent and independent judges. Coming to the Indian Evidence Act 1872. This is the main law that governs the admissibility and relevancy of evidence in criminal trial in India. It contains various provisions that ensure the due process of law and fair trial, such as presumption of innocence, the burden of proof, the standard of proof, the rule of hearsay, the rules of confession, the rules of privilege and the rules of judicial notice. The Indian Penal Code 1860, this is the main substantive law that defines the offences and prescribes the punishment for them in India. It contains various provisions that ensure the due process of law and fair trial, such as the general exceptions, the principle of criminal liability, the mens rea, the actus reus, the defences and the mitigating factors. Coming further to the international conventions and treaties on fair trial. India is a party to various international conventions and treaties that protect and promote the right to due process of law and fair trial, such as Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on Rights of the Child, the Convention on Elimination of all form of discrimination against women, and the Convention against torture and other cruel, inhuman or degrading treatment or punishment. Thus, the various rights of the accused persons are ensured by the statutes like the right to fair trial via the right to self-incrimination, the right against double jeopardy, the right to legal representations and the right to be informed of the charges and evidences, etc. The landmark case laws. The Supreme Court has interpreted the concept of procedure established by law under Article 21 of the Constitution in relation to Article 14, 19, 20 and 22 are. First is A.K. Gopalan versus State of Madras, AIR 1950, Supreme Court, page number 27. This was the first case that dealt with the interpretation of Article 21 and its relation to other fundamental rights. The petitioner A.K. Gopalan was a communist leader who was detained under the Preventive Detention Act 1950 without trial. He challenged the validity of the act and his detention on the ground that they violated his fundamental rights under Article 19, 21 and 22. The Supreme Court held that the procedure established by law under Article 21 meant any procedure prescribed by a valid law enacted by the Parliament or state legislature, and the courts could not examine its fairness, justice or reasonableness. The Supreme Court also held that Article 21 was an independent and self-contained right, and it was not subject to the restrictions imposed by Article 19 or the safeguards provided by Article 22. Therefore, the Preventive Detention Act and the detention of the petitioner were upheld as constitutional. The second case is Maneka Gandhi versus Union of India, AIR 1978, Supreme Court, page number 597. This was the landmark case that changed the course of interpretation of Article 21 and expanded its scope and content. The petitioner Maneka Gandhi was a journalist whose passport was impounded by the government under the Passport Act 1967 without giving any reasons. She challenged the validity of the act and the impounding of her passport on the ground that they violated her fundamental right under Article 14, 19 and 21. The Supreme Court held that the procedure established by law under Article 21 must be right, just and fair, and not arbitrary, fanciful or oppressive. Otherwise, it would be no procedure at all and the requirement of Article 21 would not be satisfied. The Supreme Court also held that Article 21 was not an isolated or exclusive right, but it had to be read in conjunction with other fundamental rights, especially Article 14 and 19. Therefore, the procedure established by law under Article 21 must also satisfy the test of non-arbitrariness under Article 14 and the test of unreasonableness under Article 19. The Supreme Court also held that the right to life and personal liberty under Article 21 included the right to travel abroad. The right of impounding of passport of the petitioner was an infringement of his fundamental right. Therefore, the Passport Act and the impounding of the passport of the petitioner were declared as unconstitutional. K.S. Puttaswamy versus Union of India, 2017, Volume 10, Supreme Court Cases, page number 1. This was the historic case that recognized the right to privacy as a fundamental right under Article 21 and overruled the earlier judgment that has denied it. The petitioner K.S. Puttaswamy and others challenged the constitutional validity of Aadhaar scheme and Aadhaar Act 2016 on the ground that they violated the right to privacy of the citizens. The Supreme Court held that right to privacy was an intrinsic part of right to life and personal liberty under Article 21, and it was protected by the other fundamental right as well. The Supreme Court also held that right to privacy was not an absolute right, but it was subjected to reasonable restriction imposed by the state for legitimate public interest. The Supreme Court also laid down the criteria for testing the validity of any law or action that infringed the right to privacy, such as the existence of a valid law, the necessity and proportionality of the measure, and the existence of procedural safeguards. The Supreme Court also referred the matter of the Aadhaar scheme to the Aadhaar Act to a smaller bench for further adjudication. Next case is Keshar Singh, Ram Krishna Patel and others versus State of Maharashtra and others, 2017, Volume 14, Supreme Court Cases, page number 1. This was the case that upheld the unconstitutional validity of the Maharashtra Control of Organized Crime Act 1999, which was challenged on the ground that it violated the right to fair trial under Article 21. The petitioners Keshar Singh and others were accused of being members of an organized crime syndicate and were booked under MCOCA. They contended that the MCOCA violated the right to fair trial under Article 21 by providing for harsher punishment, longer period of detention, admissibility of confessions made before the police, and reversal of the burden of proof. The Supreme Court held that MCOCA was a valid law enacted by the state legislature to deal with the menace of organized crime, which posed a serious threat to the national security and public order. The Supreme Court also held that the Act did not violate the right to fair trial under Article 21, as it provided for adequate safeguards and checks and balance to protect the rights of the accused person, such as the requirement of prior approval of the competent authority, the recording of the confessions in the presence of a judicial magistrate, the opportunity to retract the confessions, and the presumption of innocence until proven guilty. The Supreme Court also held that right to fair trial under Article 21 was not a static or a rigid concept, but it had to be balanced with the larger interest of the society and the state. Tufan Singh versus the State of Tamil Nadu, cases of 2020. This was the case that clarified the legal possession regarding the admissibility of confession made before the police officer under NDPS Act of 1985, which was challenged on the ground that it violated the right against self-incrimination under Article 20, Clause 3 and the right to fair trial under Article 21. The petitioner Tufan Singh was arrested for possessing and trafficking narcotic drugs and was booked under NDPS Act. He made a confession before the police officer, who was also the investigating officer, which was used as evidence against him. He contended that the confession was not voluntary and it was inadmissible under NDPS Act, as it violated his right against self-incrimination under Article 20 Clause 3 and his right to fair trial under Article 21. The Supreme Court held that the confession made before the police officer under NDPS Act was not admissible as evidence, as it violated the right against self-incrimination under Article 20 Clause 3 and the right to fair trial under Article 21. The Supreme Court also held that the police officer under NDPS Act was not an independent authority, but a part of the prosecution, and therefore the confession made before him was not reliable or trustworthy. The Supreme Court also held that right against self-incrimination under Article 20 Clause 3 and the right to fair trial under Article 21 were essential features of the constitutional democracy and the rule of law, and they could not be diluted or compromised by any statutory provision. Next case is Indian Social Action Forum versus Union of India. This is of 2020, volume 10, Supreme Court cases, page number 274. This was the case that challenged the constitutional validity of the Foreign Contribution Regulation Act 2010 and the Foreign Contribution Rules 2011 on the ground that they violated the right to freedom of speech and expression under Article 19(1)(a) and the right of freedom of association under Article 19(1)(c) of the individual and the non-governmental organization engaged in social activism. The petitioner, Indian Social Action Forum, was an NGO that received foreign contribution for its activity. It contended that FCRA and the FCRR imposed unreasonable and arbitrary restriction on the receipt and utilization of foreign contribution by the individual and the NGOs, and that they were used as a tool to harass and intimidate the dissenting voices and the civil society group. The Supreme Court held that the FCRA and the FCRR were constitutionally valid laws enacted by the Parliament to regulate and monitor the foreign contribution received by the individual and the NGOs in order to prevent any adverse impact on the nationality, security, public interest and sovereignty of the country. The Supreme Court also held that FCRA and the FCRR did not violate the right to freedom of speech and expression under Article 19(1)(a) and the right to freedom of association under Article 19(1)(c), as they were reasonable restrictions imposed by the state under Article 19 Clause 2 and Article 19 Clause 4 respectively in the interest of general public. The Supreme Court also held that above legislations did not infringe the right to life and personal liberty under Article 21, as they did not prohibit or curtail the legitimate activities of the individuals and the NGOs, but only regulated the source and manner of the foreign contribution. In case of Rajiv Suri versus Union of India, this was the case that challenged redevelopment project of the Central Vista area in New Delhi, which involved the construction of a new parliament building, a new prime minister's residence, a new vice president's residence and other government offices and buildings on the ground that it violated the right to life and personal liberty under Article 21 and the right to a clean and healthy environment under Article 21 read with Article 48 of the Constitution. Concluding the topic, in conclusion, it can be said that the due process of law and right to fair trial are the cornerstones of the criminal justice system in India. They are enshrined in the Constitution as well as in various statutes, case laws and international conventions. They ensure that every person is treated equally and fairly by the law and no one is deprived of his life or personal liberty without following the established rule and procedures. They also protect the individual rights, due process, public trust and rule of law. However, there are also many challenges and issues that affect the implementation and realization of these rights in practice, such as the delay in trials, the overcrowding of prisons, the lack of legal aid, the misuse of power, the corruption, the media trial and the violation of human rights. Therefore, there is a need to reform and strengthen the criminal justice system in India and to ensure that due process of law and the right to fair trial are respected and upheld in every case. This would not only benefit the accused persons, but also the victims, the society and the nation as a whole. Due process of law is the right of every citizen, even those who are accused of breaking the law. Sonia Sotomayor. I hope this lecture will be useful for you. Thank you and have a nice day.